Court news moves incredibly fast, and you can't keep up. Lucky for you, I don't have hobbies. Happy Tuesday, everyone. I'm Brian, and this is the morning report on the federal courts for August 12th, 2025. Please do me a big favor. Drop a comment or a like, and if at all possible, watch the video all the way to the end. It helps other people see this stuff, and this is important. All right, are you ready? Let's do this. Yesterday, the Northern District of California opened its trial in Newsom v. Trump. It's the case about the Trump administration using the National Guard in California. The audio from that trial is and will be available online if you'd like to check it out. I listened to some of it on YouTube. Now, the case is revolving around whether the military, in this case the Marines, and the federalized National Guard violated the Posse Comitatus Act, which you can read at 18 USC 1835 if you would like. In his own words, the judge restated the meaning of the act as, the military cannot be used to enforce domestic laws unless expressly authorized by the Constitution or an act of Congress. So, for the next 2 days, the court will hear evidence on a question of fact. Was the military used to enforce domestic law? And if so, whether there continues to be a threat that it will be done again. And then, on Wednesday, the court will address the legal arguments that have been raised by the government, and there are 4 of them. 1, Posse Comitatus is a criminal statute, so you can't use it in the civil court. 2, California cannot bring a claim that the military was acting ultra vires, which means beyond their legal authority, under these circumstances. 3, California lacks standing to bring this claim. And 4, there is another statute, 12406, under which the National Guard was federalized, and that statute exempts this conduct under Posse Comitatus. So, that is how the next 3 days of this trial are expected to play out. We'll be going into day 2 of answering those factual questions today. I'll keep an eye out on what's going on and report back to you tomorrow. This is probably the first real trial for the administration's policies, so we'll see how they hold up. All right, now we are going to look at Citizens for Responsible Ethics in Washington, the Office of Management and Budget. This is a case about the Public Apportionments Database. Wake up! This is really important. I know it sounds boring. This database is publicly available, and it lets us all know how the federal government is actually spending the money that Congress has appropriated. So, remember when DOGE was created to make sure the government wasn't wasting any money? All that data was right here. But on March 24th, right in the middle of DOGE doing all of its stuff, the government removed the database from the internet. So the public could no longer see how the executive branch was actually spending the money that Congress appropriated. And Citizens for Responsible Ethics in Washington, or CREW, the plaintiff in this case, basically just sits and watches that database all day to make sure that the money is being spent properly. So when the database went away, they sued the government. And there's some complicated civil procedure stuff in here about partial summary judgments and stuff. I'm going to skip over that, just get to the good stuff here. The DC Court of Appeals has ordered that the database be restored and that the executive branch disclose all of the materials that it's been hiding since March. Now, the problem is, this may have impacted the budget process, and it's a little late now. But it is what it is. The database is going back up, unless the president appeals, which he may. But the data being available is a good thing. Sunlight is the best disinfectant. Okay, USV Russell, my personal nightmare. This is the case where the Trump administration is suing the federal bench of Maryland. And yesterday, the judges filed more support for their motion to dismiss. Now, I've said this before, no matter what is going on, I would not want to take on a panel of judges in court, but Godspeed. Now, this filing was not their entire argument. It was just a response. It was like the little responses to specific arguments that the Trump administration had made in its last filing. And they made 3 main points in response. 1, they said, this suit is unprecedented. And they quote the executive branch, the Trump administration, saying that the suit, quote, is not entirely unprecedented. And they say, because they came up with a situation where it's kind of sort of happened maybe once before, maybe. And the judges say, if you're out scraping for a single example of something kind of like this ever happening before in history, it's never happened. Number 2, the executive branch doesn't actually have any real law to base their cause on. And we call this lacking a cause of action. There's no statute or anything. In fact, the Trump administration just quotes a case that says not every case needs a cause of action. And the judges say, first of all, the case that they cite is in another universe from this situation. And second of all, every case has to have a cause of action. which it does. That's just Law 101. And then 3, the judges quote the executive branch as essentially admitting that the judges are immune from this case. The administration talks about sovereign and judicial immunity, but then they never actually come to a point. But by bringing it up, they just sort of prove their point. The judiciary has immunity too. Once again, this is why I would never mess with judges like this. It's like writing a letter with bad grammar to an English teacher. It's going to come back covered in red pen. Don't mess with them. Okay. Now we are going to step out of our normal area for just a moment and talk about a case that doesn't involve the federal government, but I think is really important, so it's worth catching up on. Central Maine Power Company is a case about money in politics, which is obviously a very important topic. And this story is not going to have a very happy ending. I don't want you guys to be dissuaded, but I do want you to understand the rules and the law here a little bit, even if it's not super happy. A couple of years ago, voters in Maine passed a referendum that banned foreign government and companies with 5% or more foreign government ownership from donating to referendum races. And both the federal district court and yesterday, the First Circuit Court of Appeals held that the law violated the First Amendment. They said the prohibition is overly broad, silences U.S. corporations on the mere possibility that foreign shareholders might try to influence its decisions on political speech. Now, voters approved this referendum with an 86% majority after a Canadian-owned utility tried to influence a project in Maine and people got mad. So this decision, it's definitely rooted in Citizens United, which recognizes that a corporation, U.S. or otherwise, has a First Amendment right to free speech. And for the moment, unless that changes, that free speech means spending money to change and impact politics. And that money, according to the ruling, can come from inside or outside of the United States, because this case essentially states that a U.S. corporation is American, even if its owners aren't. So that's a little concerning, but I thought it was noting, even if it's outside of our normal wheelhouse. All right, that is your Tuesday morning report on the past day in federal courts. Again, please leave a comment or like to get it out there. I would appreciate it. And if you know someone else who would like this, please share it. Otherwise, keep watching, everybody. I'll keep going. Thanks a lot, and have a great Tuesday. Thanks a lot.